Hello, welcome back to our video updates. It's Sade. Today's video is covering what we call leaseback agreements or seller's leaseback or seller's temporary lease agreement. And this type of lease agreement is used during a real estate transaction between the buyers and the sellers. And typically, the reason why a seller would need to lease back is that they want access to the funds or a guarantee of closing on the deal. And at the same time, they do need a few days to be able to move. So let me give you some scenarios under which that would be helpful to the seller. If there's a closing date set up, sometimes closings tend to fall through where for whatever reason the buyers are not able to continue with the transaction, maybe because their financing fell through or something else happened. And if the seller has already started moving seller's belongings into a new house or a new space where they're renting, now they're stuck with continuing to pay for the house that they thought they were going to sell and also paying for the new place that they've just moved all their belongings into. So some of the sellers want that security that the closing actually already took place before they then start moving their things, so that A, there's no double moving, logistically speaking, and B, so that they don't have to be paying for two residences at once. And then the other reason why some sellers would need this type of agreement is if they are trying to use the funds from the closing to purchase that next place where they will be moving to. So typically they want to use it to buy a new house or to put down a down payment on a new house. And so they would want to close first because then they have access to the funds. Once the transaction is funded at closing, they have access to those funds, then they can now pay for the other property that they found, and then they'll be able to move their belongings from the house that they sold after maybe a few weeks or a few days, right? So that's when they need the buyer to give them a leaseback agreement or seller's temporary lease agreement to allow them to stay a little bit longer after the closing so they can move their things and also clean up the property and leave it in the condition in which the buyer originally saw it. And then they can move into the new place because now they have money and they have some time. And the other scenario in which some sellers would like that is maybe because they're building a new home, which is similar to the one that I just described, or because their kids are in school in that school district and they want that school year to end, but for some reason the closing date is before the end of the school year. So they just, maybe it's just off by a few days or a few weeks. So the real estate associations here, they have some standard forms that they suggest that people use, and the form only provides up to 90 days. So the buyers and the sellers can negotiate whatever they want, but that particular form is only good for those sellers' temporary leases that are not for more than 90 days. And I think the reason why they do that is to discourage people from doing a leaseback that's long term, longer term. And because the Texas Property Code, it has different treatment for those short-term rentals. And it's a lot easier to get somebody out under a short-term rental than it is if they had a longer rental period. So I'll go over the terms of a typical leaseback agreement. Here in Texas, that's what it's called. In other states, I believe they call them rent-back agreements, and they have so many other things that they call them. But it's essentially a lease that the seller has for the property that the seller just sold, just to allow them a little bit of time to move out. And so what are the conditions under which a buyer would want to accept such a deal? Because most buyers want to move in right away once they've purchased the property. I think when you as the buyer are in a situation where they tell you up front that the seller might need a leaseback agreement, then you have a little bit of a leverage, because some buyers would walk away because they're very uncomfortable with that kind of a deal. And the buyers that are willing to work with the seller, their offers might be considered above the other buyers' offers, even if the other offers were higher. The other reason is maybe you can get a better deal if you would agree to a lease back. So you could negotiate the contract price based on the need for a lease back as well, depending on how the market is. If it's a seller's market, that might not work so well, but it still helps that you're a little bit easier to work with as a buyer. And then, of course, if the leaseback agreement is not mentioned up front and it just happened when you already negotiated the contract price, you can, of course, factor that into the terms of the lease agreement itself. Not really a profit-making lease agreement. It's more of an agreement that makes sure that the buyer does not lose money while waiting for the seller to move out. So if you're that kind of a flexible buyer, you might get a better deal overall. And in that lease agreement, you can get a deposit that makes you feel comfortable to be able to move forward with such a transaction, which is, it's not unusual, but it's not what most buyers would like. So what are the kinds of terms that are inside a typical leaseback agreement? The term of time is very important. So you have to determine how long is this lease agreement going to be for. Most of them are for just a mere number of days, and some of them are for weeks, and some of them might be for a month or two. So you'll put that inside the agreement. It's in writing, of course. And then the second most important thing is to figure out how much is the daily rate of rent. So typically it's going to be based on the rental rate in that area. I personally think that's a good way to figure it out, unless the cost to buyer for carrying that property is more than the average rent in the area. So what do I mean by that? Let's say you have a buyer that's financing the deal. They did not pay cash, and so they have a loan on that property, and the principal, interest, property taxes, and insurance costs to carry that property is $3,000 a month. Basically, the mortgage plus the escrow payments is $3,000 a month. Then that means that when you divide that by 30 days, the daily rate will be $100 a day, and so that's what will be inside the contract. The other term that's important is to figure out, let's say the term of time ends. You agreed to 30 days, which starts from the date of closing, and the seller refuses to move out after that 30-day period or fails to move out. We have a period we call the holdover period, because they're holding over than what you originally agreed to. So you have to figure out how much is the holdover period going to cost the seller. And this is mostly just an amount that would incentivize the seller to move fast. So it should be high enough where it is a little bit painful. So let's say that in that scenario that I gave you, the mortgage and escrow was $3,000 a month, and so it's $100 a day to the buyer. That's what it's costing the buyer to carry the property. Then you'll charge the seller that cost of $100 a day. If the rental rates in that area are more than $3,000 a month, then of course you would use the higher number and divide by 30. So let's say you have 30 days in your agreement, and then the seller after 30 days refuses to move out. You have that holdover rate, which is going to be higher than the rental rate. So the holdover rate could be something like $300 a day, just to motivate the seller to move out faster. And they will owe you that for as long as they're holding over, for as long as they're over the originally agreed upon 30-day period. You would of course need a lawyer to help you enforce that if the seller does not voluntarily pay up. The other part of the agreement that's really important to keep in mind is that you need a security deposit up front, and that security deposit is paid at closing. because that's the first day that that rental agreement starts. And it's not actually money that you're getting from the seller, it's money that you're getting as a credit to your escrow funds. So let's say you were buying that property for $300,000, and now there is a security deposit of $1,000. Then they will deduct that $1,000 before paying the proceeds to the seller. So that's how the security deposit would work. To get a security deposit that's large enough to cover any damage to the property beyond normal wear and tear. So let's say when the seller is moving out, they accidentally damage things, and the condition of the property is different from when you walked through before the closing, then that security deposit is supposed to help you with those costs. And sometimes you also want the security deposit to be large enough to cover an instance where the seller refuses to pay the holdover, fees, for instance, or even some other fees that are agreed upon in the contract. So you want it to be a sizable amount, so that in case you never are able to collect a dime after that closing date, that you're actually doing okay. So that's how I will do it. The other thing, seller will be paying for the utilities as well. And then also any repairs needed will be on the seller. Now, of course, because there's been a closing done, the property no longer belongs to the seller. So the seller is now the tenant and you as the buyer are the landlord. So you do want to address insurance in case of some damage to the physical property, the real estate itself. And then you also want to address insurance in case of damage to the belongings inside the house. And those would be the seller's belongings. So we always say that the seller should carry rental insurance to cover their belongings, and that the buyer should carry that hazard insurance because the ownership is now with the buyer. So even if the parties think that they can allow the seller to continue to carry the insurance, the hazard insurance on that home, I don't think that the insurance provider would cover any claims because the property is no longer in the seller's name. So you could also just talk to the insurance companies and see what they have available for a buyer to cover the hazard insurance, and also have a landlord type of insurance at the same time for those 30 days. So you can always transfer all those costs to the seller who's trying to have a leaseback agreement. So those are important things to keep in mind, and I will say those are the main terms that you want to discuss, and put everything down on paper, of course. If there's any dispute and one of you has to sue the other person, whoever wins in court is going to be able to get their attorney's fees back from the other party, because that's pretty standard with real estate transactions and contracts. So that's also in that lease agreement. And then the thing that people always ask is, well, I'm a buyer and I took a loan stating that I was going to be residing in the house, like an owner-occupant type of loan. And now would I be committing fraud if I give a leaseback agreement to the seller? And the answer is no, because this is not a typical lease agreement. It's just an agreement to help facilitate the sale of or purchase of the property itself. So it does not trigger any fraud, in my opinion, and you shouldn't have to worry about that. But of course, there's the concern about what if the seller refuses to move out? What if the seller doesn't move out on time? And what if the seller damages the property at the time of moving out, so that the condition is different from when I saw it prior to closing, because you contracted for the price based on the condition prior to closing. So what we would say is, get that security deposit that's high enough, and of course, also do a walkthrough before the seller moves out after the lease agreement ends, and you can definitely charge them for more if there's more damage than what you anticipated, and you hopefully can collect that. If you're not able to collect, unfortunately, you do have to involve a lawyer to help you make demand and collect on those things. In the very small chance, and this doesn't happen too often, where the seller just doesn't move out and doesn't pay anything else, then you have that holdover provision in there and it's triggered, but you do need a lawyer to be able to enforce that, and go and evict that seller from that property because it's yours. So you will have to spend some money, but ultimately you'll win that kind of a lawsuit, hopefully, and you'll be able to recover all your fees, the court costs and the legal fees involved. But it will be a little bit of a hassle. So that's why most buyers are worried about these types of arrangements. But it's not uncommon, and most people actually do keep their word. Even if they hold over just a little bit, it's not by much. And most of the time, the buyers do not have to evict the sellers under these types of lease agreements. So that is my overview of the leaseback agreements. I'm trying to think of any other questions that people have asked, and I can't think of anything. So not super convenient for the buyers most times, but it's not a terrible thing if you really, really want that property and you can afford to give them that leaseback agreement. If you have any other related topics that you'd like me to cover, please put a comment below. Thank you for watching. As always, if you like the video, hit the thumbs up, and of course you can subscribe to my channel for more videos. Thanks for watching, and I'll talk to you next Friday.